Yeah, it looks like a lot of folks have logged on, so we'll go ahead and get started. Again, welcome to today's webinar. I'm Steve Barton, with a partner with Lewis Thomason, and along with my law partner Matt Drake, we're going to be presenting today's webinar. At the end of it, I'm going to go first, and then Matt will follow up. Feel free to ask any questions. You've got a chat box, so feel free to do that, and we'll do the best we can to respond. Our firm has got 3 offices in Memphis, Nashville, and Knoxville. I'm actually in Memphis, and Matt is in Knoxville. And the topic of today's webinar is the law of construction claims. And basically, that's an overview of the legal principles that control a typical construction claim, primarily a lawsuit. And of course, there's a million different varieties, a million different ways that can actually evolve. But these are some kind of the basic 101 principles that control. And at the end, Matt has added some new information about talking about COVID and how it's impacted construction litigation and just construction in general. So that's kind of an added bonus material that we've added here towards the end. Ironically, this is a topic that you never have to use because if you have to use the law of construction claims, that means you're involved in a construction claim. And I'm sure most of you folks watching this hope that doesn't happen. But in today's litigious society, it does happen a lot. And if you ever are involved in one, or even contemplating filing one, hopefully this will give you some information that will help you to understand the process and navigate it and make it a little bit easier on you. Again, make sure I can operate this thing. Tanya, can you help me there? Well,
I just gave you control. You should be able to take it now. There you go.
Okay, great. I appreciate that. Yeah, again, this is kind of an overview of the basic concepts. Well, I'll get to that point. This is an overview of the basic concepts in a construction claim, which usually is going to include, again, it varies, architects, engineers, contractors, owners, and as we're going to talk about, a lot of the ideas and concepts that involve these different parties are the same, but there's different terminology. You've got design professionals, the architects and engineers. You've got your contractors working in the trades. And all this, we'll see some of the terminology is different. There's some different semantics. The basic concepts are the same. The 4 general topics we're going to cover are construction claims in general, typical liability claims, causes of actions, the one you see most commonly, typical defenses to liability claims, and typical damage claims, how the damages are calculated, the different varieties there. And then, as I mentioned at the end, Matt is going to talk a little bit about COVID. So the first thing, I guess, to begin at the beginning is what is a claim? According to, and it looks like I'm caught up with my screen here, a claim, according to Black's Law Dictionary, is simply a demand for money or property. It's a pretty broad term, which includes generally lawsuits and arbitration. You could throw mediation in there, but lawsuit and arbitration is kind of what we're talking about today. And in the construction context, it's almost always going to involve an error or omission in either design or construction. And most of y'all probably know this, but just to briefly, the difference between a lawsuit and arbitration is a lawsuit is actually, it's a formal process, obviously. A complaint is filed in the court by the plaintiff or plaintiffs. The defendant files an answer. There are very technical rules about procedure and evidence. And then if the case doesn't settle, and most of them do, but if it doesn't, then it'll ultimately be decided by a judge or a jury, which is obviously a binding ruling. An arbitration is kind of lawsuit light. It also has procedural and evidentiary rules, but they're a little bit looser, and it's heard in front of an arbitrator or a panel of arbitration as opposed to a judge or jury. And so if the case doesn't settle before the conclusion, the arbitrator decides it, and again, it's binding. Whereas a mediation which is frankly where most construction lawsuits end up getting resolved, is a less formal process even, and it's kind of a settlement conference where you've got a mediator that works back and forth between the parties to try to find common ground and resolve it. But the difference there is, the distinguishing factor is that in mediation, it's not binding. If you can't get it settled, you can't agree, you can walk away and come back and try later. So that's kind of how the basic three procedures work. Now, next is, how do claims arise? There's basically three ways, kind of common sense. Number one, you can become personally aware that you've made an error or miscalculation, which obviously can happen. And if that does happen, then you can, that's a good thing that you noticed it, because you can try to resolve it. Or the error or miscalculation alleged can be brought to your attention by a third party without a lawsuit yet, or arbitration. And again, that's good because it gives you a chance, hopefully, to resolve it before a lawsuit's filed. The third is kind of the bolt from the blue, where you're suddenly served with a complaint or a notice of arbitration. And usually you'll have a pretty good idea that it's going to happen. But occasionally it does happen, there'll just be the bolt from the blue. And so then suddenly there's a claim against you. So the next question is, how do you respond? The first thing you do is call your lawyer. If you've got an in-house lawyer, call them. Frequently, they're going to be more transactional as opposed to litigation. But your next phone call is to notify your liability insurance carrier. And frequently, frankly, usually that's one and the same thing, because one of the things the liability carrier will do is provide you with defense counsel, and they'll generally handle the defense of the lawsuit. Now, the typical insurance policy is going to say that you have to provide that notice as soon as practicable. And that's kind of a term of art, which has been defined various ways, but basically it means as soon as reasonably possible. And with today's technology, with telephones and emails, that's virtually immediately. So go ahead and do that. Notify your lawyer and your insurance company. The problem, if you don't, is that it could conceivably lead to a loss of coverage if you wait too long. If you hope it'll go away or get worked out, because with the passage of time, you can lose evidence, witnesses can disappear, and that can prejudice the ability of the insurance company to defend the case. So if you wait too long, they can even deny coverage. So don't put yourself in that position. Next, we'll talk about the four most common causes of action. These are kind of the swords that the plaintiff, the person bringing the claim, uses the allegations made against the defendant to try to get damages, usually in the form of money. There's a lot of them, but I've just focused on kind of the big four here. First is negligence, and that's measured in two ways. First, for design professionals, it's the standard of care is the standard. And for contractors or folks in the trades, it's the term of art is workmanlike performance. But as we'll see, they're in reality very similar. Then there's breach of contract, breach of warranty, and negligent misrepresentation. We'll talk about each of those. First, let's talk about negligence, just as a generic term. Everybody's familiar with the term negligence, but let's just look at exactly what it is, and then I try to come up with an example that might help explain it. Negligence is the failure to use ordinary, reasonable care. It is either doing something that a reasonably careful person would not do, or the failure to do something that a reasonably careful person would do under all the circumstances in the case. And that's sometimes called the reasonable man test. What would a reasonable person do? But I think one of the keys there is the circumstances, because frequently the circumstances are going to determine what's reasonable. And this example I came up with is probably pretty simplistic, but to me it was pretty illustrative. If you're at just a garden variety construction site and working on a house, and you're coming back early the next day to continue working, and there's some lumber and some other equipment, you'd probably be okay reasonably. In ordinary care would be just to cover it up with a tarp, something like that. Now, if you were aware that there was an 80% chance of thunderstorms with winds up to 40 miles an hour, then just covering the material with a tarp would not probably be reasonable and ordinary care. And so those are kind of the extremes. But where it gets a little dicey is, what if there's a 50% chance of rain, or a 20% chance, or a 1% chance? It becomes very difficult to draw the line between what's reasonable and what's unreasonable, and it becomes a gray area. And frankly, that's why so many cases settle, because it's very rarely that clear cut. And when you get into that gray area, most times the party will end up settling instead of rolling the dice at a trial. Next, let's look at negligence in the context of professional liability. And there, the measure is the standard of care is the test of professional negligence. And the standard of care, a term you've probably heard, has been defined by the restatement as one who undertakes to render services in the practice of a profession or trade is required to exercise the skill and knowledge normally possessed by members of that profession or trade in good standing in similar communities. You'll see that in a lot of complaints, and that's kind of the restatement language. But in plain English, what that means is it's basically what other competent members in your trade or profession would do under the same or similar circumstances. So that begs the question of how is the standard of care determined? The failure to live up to the standard of care is negligence, but how do you know what that is? Well, that's determined by experts in the same or related field. So since we're talking about design professionals, if it's an architectural issue, it would be other architects as experts. Same would go for engineers. And that's where you've probably heard the term the battle of the experts. And that's where, if the case is going to be litigated, that's frequently where it'll be determined is, who had the better experts, or at least the experts that was the finder of fact believed. And if you're watching this and you're involved in the construction profession one way or the other, you're also an expert. If you're sued as a defendant, an architect, an engineer, or a contractor, you're an expert. You can testify as an expert. But frequently, depending on the nature and the size of the case, folks will bring in outside experts kind of for reinforcements. But ultimately, the standard of care is going to be determined by experts. Now, the one thing I forgot to mention earlier is one of the themes we'll see is a lot of these claims, kind of these swords, these theories of liability against the defendant overlap. The same wrongful act will be covered by different theories. And leading up to that point is this duty to comply with the standard of care is typically, I'm sure always, frankly, written into a design contract. The architect's and engineer's contract is going to have the requirement, and this I pulled out of an AIA contract. The design professional services shall be performed in a manner consistent with that degree of skill and care ordinarily exercised by practicing design professionals performing similar services in the same locality and under the same or similar circumstances and conditions. So as you can see, that language pretty much tracks, not word for word, the language in the restatement. Now, the good news is that under the standard of care measurement standard, perfection is not required. A professional is not negligent merely because of an unsuccessful result or an error in judgment. It is negligence, however, if the error of judgment or lack of success is due to the failure to use the required care and skill as defined in these instructions. And I know that's kind of a mouthful, so I tried to kind of think of an example to explain that. And so what I came up with is you've got an architect, and he's designing a building, and he has a choice between two materials, A and B. And after the architect carefully researches the issue, does his due diligence, looks back on some prior projects, consults with his colleagues, he chooses A, material A. If it turns out to be ultimately the wrong choice, and it could, and it doesn't perform properly, but even in those circumstances, he's probably not negligent. It wasn't perfect. There was a problem, but he used his due diligence and exercised his skill and judgment. So he's probably not negligent. Now the owner is going to say he is, probably, but he certainly got a good argument that he wasn't. But if the same architect chooses A just because he's kind of familiar with it, here, I'm sorry, I need to get caught up. If the same architect chooses A just because he's familiar with it, he's behind schedule, he's running late, doesn't have a lot of time to think about it, he used it before, he figures A is okay, that should work, gets the same result, under those circumstances, he is negligent because he's failed to use the required knowledge and skill in making a decision. Now, to me, he'd be negligent even if he got a good result. It may have been an all's well that ends well, but if you don't use that skill and that learning and use that due diligence, then and something goes wrong, you're going to be negligent. So let's look at this concept of negligence as it applies to contractors and folks in the trades. And here's the language that the Tennessee cases use to define that standard. It says, in Tennessee, every construction contract is accompanied by an implied obligation to perform the service skillfully, carefully, and diligently, and in a, here's the term, workmanlike manner. The proper standard against which to judge the defendant is the standard of workmanship prevailing in the area, coupled with the conformity to the applicable codes. And as you can see, that's different language than the quote unquote standard of care, but it's the same general concept. Both disciplines, whether you're a design professional or you're a contractor or in a trade, you have to exercise independent judgment and conform to certain standards. But you do so with different terminology and terms are used, but that's just the basic general concept. Now let's talk a little about breach of contract, which is another one of the big claims you'll see in virtually any complaint. Just to define it briefly, again, back to Black's Law Dictionary, a contract is an agreement between two or more persons which creates an obligation to do or not to do a particular thing. You probably didn't have to come to the seminar to learn that, but that's just the basic idea of what a contract is. But in the context of a lawsuit of breach, a party that does not perform according to the contract terms, i.e. as he has promised, is in breach of the contract. And when that happens, the non-breaching party, the innocent party, has two remedies. Number one, he has a claim for damages, usually in the form of money for what that breach of contract allegedly caused him. And the other one is if there's a breach of contract, the non-breaching party has the right to repudiate the contract. In other words, he can stop performing, or he or she or it, the company. That's frankly not used as often. Generally, in my experience, 9 times out of 10, it's a claim for damages, but that repudiation capability is there. But one thing to be aware of, especially if you're thinking of repudiating a contract, is that the breach of contract has to be material. Just a minor or insubstantial failure of a party to meet the terms is not going to allow you to get damages or to repudiate. So it's got to be something significant, which is, again, kind of a common sense thing. Then kind of back to the overlap theory, you'll note that a failure in the design professional context to perform in a manner consistent with that degree of skill and care ordinarily exercised by practicing design professionals, or a failure to construct in a workmanlike manner is generally going to be both a tort for negligence and breach of contract. And so it's just kind of a side note, more often than not, the same, as I mentioned before, the same wrongful act will be covered by multiple different claims. And that's kind of, I guess you'd call it the kitchen sink theory in complaints, that the plaintiff's lawyer is going to throw everything in there that he thinks could conceivably, reasonably, plausibly, even sometimes implausibly apply, just because he wants to be sure he's covered all his bases. And so that takes us to the third one, breach of warranty. The definition of a breach of warranty, or a warranty, is a promise or agreement in a contract that is either express or implied. Express warranties are explicit promises, and we'll look at one of those in a minute. Next slide, I think. While implied warranties can exist even if not written in the contract. Now, these are more common in the typical construction contract as opposed to a design contract. They're very similar to a breach of contract, but they're more limited in that a breach of contract allows you to claim money damages and repudiation. Breach of warranty does not allow you to claim repudiation to repudiate the contract. But as I said, since repudiation is pretty uncommon, as a practical matter, they're pretty much the same thing. And you'll see the express language of a breach of warrant or a warranty in a contract or construction contract is the contractor warrants to the owner and architect that materials and equipment furnished under the contract will be of good quality and new unless the contract documents require or permit otherwise. The contractor further warrants that the work will conform to the requirements of the contract documents and will be free from defects, except for those inherent in the quality of the work the contract documents require or permit. So as we've talked about this overlap kind of concept, a failure to build the structure free from defects is also a failure to build it in a workmanlike manner. And so it's going to be a breach of contract and a breach of the warranty and negligence. And so again, we see that we have that overlap. Now, the last one to talk about is one that you'll see in virtually every construction lawsuit, but it's frankly the one that, in my experience, really has the least actual relevance, and that's negligent misrepresentation. It's got a number of elements in it. It's the defendant was acting in the course of his, her, its business or profession, which obviously would be the case. The defendant negligently supplied false information. The defendant intended the information to guide the plaintiff's business transaction, say the owner, and the plaintiffs say the owner justifiably relied on this false information, and as a result, there's a financial loss. This has a number of elements and can be kind of difficult to prove. Negligence will usually cover the same situation. I came up with kind of a quick example. I didn't put it on a slide, but if there's an owner building an arena and he's going to have a lot of concerts in it, he may need a certain level of quality of acoustics. And so the architect may have built similar arenas in the past, and he hadn't done a lot of research on it recently, but he believes that a certain acoustical material will perform properly, give the owner what he needs. He honestly believes that. He tells the owner that, the owner relies on it, but it turns out that it doesn't work right, and so he loses some concert performances because of it. The architect there would be liable for negligent misrepresentation. He negligently gave false information, but frankly, he'd also just be liable for just flat out negligence. And so again, it kind of covers the same, the two different theories cover the same problem. Now, if he knew that the acoustics wouldn't work and he just flat out told him it'll work when he knew it wouldn't, then that's fraud. That's intentional misrepresentation. That would open up, Pandora's box of punitive damages and that sort of thing. But just in the garden variety lawsuit, that's not going to be the case. Next, talk of just a little bit about. I'll get started and let Matt finish out on typical defenses to liability claims. And what I talked about earlier were kind of the swords that the plaintiff is going to use to try to get damages from the defendant. These are the shields that the defendants use to try to prevent the plaintiff from getting those damages. These are the defenses. They're the statutory defenses, and there's two primary ones. We'll talk about those. There's the comparative fault defense. There's the betterment defense, and there are certain provisions in the contract that provide defenses, limitations of liability, waiver of consequential damages, and no damages for delay. Let me see. I got to get caught up here. Let's talk about the statutory defenses. The two of those primarily, and these are time limitations. These limit the amount of time you have to file your claim. First is statute of limitations, and the next is statute of repose. Statute of limitations, to define it, is basically just a time period available to file a lawsuit. There's a little bit of a twist in Tennessee and probably in most states. The statute of limitations in construction cases that we're talking about is almost always going to be 3 years. And that's because the statute of limitations for damage to real property is 3 years. And so that 3-year clock starts to tick when the cause of action accrues, another term of art we'll talk about here in just a second. The twist is that the statute of limitations for a breach of contract in Tennessee is 6 years. And as we've discussed, most cases will involve a breach of contract of one form or another. So you might think the 6 years would apply, but the courts have determined that that the gravamen of a typical construction lawsuit is the property damage. And the gravamen is just a term that means the essence or the gist of the claim. And so the courts have reasoned that since the essence of this claim is a damage to real property, and that statute of limitations is 3 years, we're going to go with the 3 years instead of the 6, which is 9 times out of 10, that will be the case. Now, I mentioned the accrual date, which can be a cruel date in some cases, some situations. That's the date when the statute of limitations clock actually starts to run. So in a typical case, when the 3-year clock starts to run. And that's pretty easy to determine in, say, a catastrophic accident case, say a wall falls down or a parking garage collapses. Then generally that's when the 3 years starts to tick. but if clock starts to tick. But if there's a concrete slab that has a crack in it and it's not evident for some period of time, it doesn't start to, clock doesn't start to tick, it doesn't accrue until the plaintiff reasonably knew or should have known, i.e. discovered the injury or the damage, and has a reasonable idea as to the identity of those who are responsible. He doesn't have to know exactly who, he has to, but if he has no reasonable belief it's the contractor or the architect, design problem, then he has got 3 years to file that lawsuit. Now, the extension I talked about when it's a hidden problem that's the discovery rule, which is kind of a common sense situation because it would be unfair to start the clock ticking against the party if he didn't even reasonably know the problem existed. So just for a very simple example, if a crack started forming in a slab on January 1st of 2021, but they weren't actually discovered, they didn't manifest themselves until June the 1st of 2021, then the 3-year clock doesn't start to tick until June the 1st of 21 instead of the January 1st. And so that's, again, kind of a common sense, kind of a fairness idea. But you need to be careful. You got to watch out because you can't wait until the full effects of the damage are known. Once the damage is discovered and the identity or reasonable belief in the identity of those who may be responsible is reasonably discovered, then the clock starts ticking. The statutory time period begins to run. In other words, it starts to run when you first see the cracks in the wall. You can't wait till the wall falls down. And so, sooner better than later. And fights over the accrual date when the clock started ticking are do or die. Because again, if you wait too long and you file outside the statute of limitations, then your lawsuit is dismissed. You may have the greatest claim in the world worth millions, but if you waited a day too long, then the court will throw that out. Although, in my experience, because it's such a harsh remedy, just to throw a case out, and also it's egg all over the lawyer's face often, the courts are very hesitant to invoke that and will kind of bend over backwards if there's any kind of gray area or wiggle room to find that it's within the statute. But some cases it's pretty clear cut and the court doesn't have a choice. Now, the last thing I'm going to talk about is the statutory defense, statute of repose. And the statute of repose is basically, it's the outer limits of what you can bring a lawsuit. The discovery rule we talked about extends it, can extend it until it's discovered, but the statute of repose says at some point it's too late. You can't file your lawsuit, and because when that statute of repose period runs, your lawsuit is in a state of repose. In other words, it's dead as a legal matter. In Tennessee, just to paraphrase the statute, any lawsuit to recover damages for deficiency in the design or construction of an improvement to real property, a construction lawsuit, must be brought within 4 years of the date of substantial completion. So that's a 4-year statute of repose. And like I said, it just brings a final limit. There's a sense of finality. And if a building was built 20 years ago and you just discover a problem, the courts have just decided, and the legislature, that's just too long. It's not fair to bring that lawsuit at that time. One quick thing is the statute of limitations runs from the date of discovery. The statute of repose runs from the date of substantial completion, which can get a little convoluted. Last thing, if there is, if the problem was not discovered because of fraud, if the builder or the contractor or whoever covered up the problem and that's why it was not discovered, then there is no statute of repose. It's like there is no statute of limitations for murder, but that's generally not the case. So anyway, I appreciate your time. I finished with my time. And again, if you have any questions at the end, you can feel free to ask them. And I'm going to hand it over to my capable law partner in Knoxville, Matt Drake.
Thanks, Steve. So let me see here, make sure I have affirmative control of this. There we go. Looks good. All right. One thing that's important to note about this presentation in general is that we're addressing a lot of topics and concepts that are common to the construction industry in general. However, every jurisdiction is going to have some nuanced distinctions and differences. This presentation is being provided within the context of Tennessee law. An example of that would be comparative fault. Comparative fault is a defense theory that is available to a defendant, typically in tort cases, most often negligence claims. Stephen mentioned several different types of claims that can be brought by a plaintiff, from a contract claim to negligence claims. Comparative fault is not relevant or is not a defense to a contract claim. However, if it's alleged that the builder did not perform work in a workmanlike manner, or if a designer did not meet the standard of care, you can allege comparative fault. Comparative fault is exactly what it sounds like. It's essentially the finder of fact, whether it's the jury in a jury trial or a judge in a bench trial, will compare the respective fault that's allocated to the parties in the case. Tennessee has what's called a modified comparative fault system. There are actually different modified comparative fault systems. Some states follow what's called the 51% rule, and then some states like Tennessee follow the 50% rule. And what that means is essentially if a plaintiff is found to have been 50% or more at fault, then they are barred from recovering anything, regardless of the judgment amount. And typically the way that's done is a jury will make a determination independently. So one determination is what the judgment would be, and the next determination is what is a comparative fault, if it is applicable. So we've got a couple of examples here that would demonstrate how that would work. Example one, the plaintiff is found to have been 45% at fault. The architect and contractor combined for 55% fault. So in this scenario, under Tennessee law, the plaintiff could recover $550,000 if the damages award is $1 million. Example two really demonstrates the difference in Tennessee's modified comparative fault system. So you've got an owner or a plaintiff owner who is at 50% at fault, and then the architect and contractor is a combined 50% at fault. Since the plaintiff is found to have been 50% at fault, they're barred from recovery. So regardless of the judgment amount here, there is no recovery for the plaintiff in scenario two. Betterment is something that is common to all of the claims that a plaintiff could bring against a defendant in the construction practice area. This is probably something we see, and I would say Steve's experience may be different, but I feel like I see this in about 95% of residential claims, and then less so in commercial and industrial construction claims. But you see it almost without exception in residential construction claims. The purpose of betterment is essentially to prevent a windfall. And what typically happens in a scenario where betterment is relevant is a plaintiff, say a residential owner, has the example here we use is it's plumbed with PVC pipe. And instead, they decide when they rebuild the house or make any changes or modifications, they use expensive copper pipe. So if your contract as the contractor would have been to have put in a PVC pipe, or if PVC pipe was existing, then that is the damages. The damage is the cost of the PVC pipe, even though the plaintiff decided to replace it with expensive copper pipe. Contractual provisions. This is the central to construction claims. The term contract itself actually has a variety of meanings. Even if you do not have a written document, you still can have a contract with a party. There's several different types of contracts, but at the end of the day, what makes up a contract are the various terms and provisions. A designer or contractor is able to eliminate and to some extent limit potential damages by placing certain language in contracts. It's important to note, however, that under Tennessee law and pretty much any law, that many of these limitations or waivers are required to be in writing. Common examples of limitations on damages would be a waiver of consequential damages or limitations of liability. For example, a limitations of liability provision might be something that says a contractor's damages or a contractor's liability is limited to, let's say, 1.5 times the fee for whatever work that's being performed. That way, a contractor knows going into it that this is my maximum exposure should things go awry and there is litigation. There's several different classifications of money damages. Under common law, damages are broken down into very, very broad classifications, and we've got 5 here with really it's a 4 and then a kind of another throw in here. But there's direct damages, indirect damages, compensatory damages, punitive damages, and then the outlier here is attorney's fees. And the reason why that's an outlier we'll discuss in just a couple of slides. Direct damages are, again, it's not a lot of these things are titled in a way that is self-explanatory. Direct damages are those damages that result directly and naturally from the wrongful act. So we're going to use example of a wall here, and I'll go ahead and tell you we'll call it a retaining wall because here in East Tennessee, there's very few construction projects that don't have retaining walls, especially if you're located in the Gatlinburg, Sevierville area. So under this example, you have a contractor's bulldozer knocks down a retaining wall. The cost of repairing the wall is a direct and natural result of the bulldozer operator's negligence, and therefore that would be the direct damages in that scenario. Indirect damages, sometimes referred to as consequential damages, are those that don't necessarily directly flow from the acts or the negligence of the defendant. They are recoverable where it's within the contemplation of the parties. So the court would look to what was the intent of the parties when entering into the contract, what is the compensation structure, and they will determine whether it was reasonably foreseeable that the parties contemplated the type of damage that is being pursued by the plaintiffs. Here's some examples of indirect damages. Again, we've got the bulldozer operator who, for whatever reason, decides to knock down a retaining wall. It's resulted in canceled concerts and lost revenue for the tickets, concessions, and so forth. These damages most likely would be deemed foreseeable if this is a established concert venue, or if there was some knowledge or discussion between the parties leading up to the contract about concerts in the future. The second example we have here is that not only are concerts canceled, but a number of artists are upset by the cancellations, and they vow never to play at this venue again, and that leads to future lost revenue for the owner. This is probably too speculative, too far removed, and therefore likely not recoverable in this scenario. Consequential damages and construction claims, whether they're direct or consequential, they're going to often arise from an owner's inability to use the property or the structure or what have you within the time that is contemplated. And they create some additional costs for that owner. Types of consequential damages, we have 5 listed. There are innumerable examples of consequential damages, but typically what we see is a lost profit due to some sort of late occupancy, lost rental income, the cost of providing separate facilities to substitute what was damaged, lost profit due to the inability to use the structure or what have you, and then additional contractor costs for delays, inefficiencies, or additional work that was not reasonably contemplated. Another thing, just for an additional example, would be fees, whether it be civil fees that are charged by a local or state governmental entity. Classifications of money damages, the most common that you'll see is compensatory damages. And these are defined as the amount, in the most simplistic form, it's the amount that is going to make the plaintiff whole or put that plaintiff in the same position he or she or they would have been but for the negligent act or the incident that resulted in damages. We've got several examples here. Again, there's an infinite amount of examples for compensatory damages, since they are the most basic and most common form of damages sought in construction claims and really any claim for that matter. You've got the wall again. We've got the retaining wall here. If it costs $50,000 to rebuild the wall, then that's the amount that it takes to compensate the owner to make that person whole. There's also a difference in value of the property, and we'll discuss that in a little bit, but that's also a potential way to measure compensatory damages. Now, mitigation is a principle of law that requires the owner not to do anything that would worsen his case or cause him or her to incur additional damages. So if the owner doesn't act diligently to repair the wall, and then a neighboring wall collapses as a result, that owner failed to mitigate or lessen the damages, and the contractor would not be responsible for the cost of repair to the second wall. Now, if we take this out another, another jump here, what if the wall then falls and damages property on a neighbor's property? Would the contractor then be liable for the neighbor or for the property owner not mitigating? Well, the typical attorney fashion, it depends, because the neighboring property owner would then have a direct cause of action against both the neighbor or the owner in the original case and against the contractor. And again, it's going to depend on the facts of the case. Now, punitive damages are a whole nother classification. Compensatory damages, indirect, consequential damages, all those damages are essentially designed to make a party whole or to address some sort of financial loss. Punitive damages, on the other hand, are designed to punish a party for wrongful conduct, and there's a threshold there. So negligence would not entitle a party to punitive damages. So if somebody just accidentally ran into a retaining wall, then that's likely not going to be a situation where punitive damages are awarded. However, if the bulldozer operator, let's say, has a history of drinking and being intoxicated on the job site, and the employer, the contractor, continues to employ that bulldozer operator on several jobs, and then the bulldozer operator gets intoxicated, runs into the retaining wall. In that situation, that goes to the next level, and it could be a situation where a plaintiff would recover under a theory of reckless conduct, and therefore a jury may be able to award punitive damages. And then the more obvious scenario is where a contractor, let's say, is angry with the property owner over a pay dispute and decides to take a bulldozer over to the wall and runs it, bulldozes it on purpose. If that's an intentional tort, and therefore punitive damages most likely would be involved and in play. Attorney's fees. The reason why this is an outlier is there's the English system and the American system of law, and under the Tennessee law, which follows the American system, is typically you're not entitled to attorney's fees unless there is a contractual provision that specifically provides that in the event of litigation, the prevailing party is entitled to recovery of their attorney fees. Now, there are some limitations to that, and judges or arbitrators tend to look at this very differently. So that is going to be something that will differ greatly from case to case. But again, the big takeaway here is attorney's fees are not going to be recoverable unless you have a contract that specifies that they are recoverable, or the claims pursued by the plaintiff fall under some sort of specific express statutory right. An example that is most common would be, let's say, a Tennessee Consumer Protection Act claim. In that statute, certain claims would entitle a plaintiff to recovery of attorney's fees, regardless of whether there's a contract in place that would provide it. Now, the reason attorney fees is something that needs to be discussed, though, is it does serve two purposes, really. One, it can serve a purpose to play a role in settlement negotiations, because as cases are litigated, the longer they are litigated, the more attorney's fees are incurred. So the party who is potentially going to be found liable has to consider that, my exposure is both the amount that the plaintiff is seeking in compensatory damages, but also their attorney's fees. And from that other perspective, if you're a plaintiff, you've got to realize that your maximum amount of recovery, if it gets to a point where it is going to be less than what you're going to pay your attorney, then if you have attorney's fee provision in your contract, you're more likely to pursue the claim. However, if you don't have such a provision in your contract and there is no statutory right, the business determination there is likely going to be, well, I need to resolve this before my attorney takes all my money. So we've modified this presentation to include a discussion of the impacts of COVID-19 and the global pandemic on the construction industry. This is not a comprehensive discussion of that topic at all. We could spend hours upon hours discussing that. And a lot of things that I'll talk about in this section of the presentation are things that you've probably experienced firsthand. And the number one issue with the impact of COVID-19 on the construction industry is its increased cost for contractors, designers, architects, engineers, because not only are they incurring additional costs to operate, but they have to take additional things into consideration. There's additional requirements imposed by governments, owners, et cetera, on projects. There's also been a significant decrease in the availability of resources due to a number of issues, whether that's shutdowns of factories overseas, increased costs in logistical or transportation of resources and materials. And then obviously that's going to result in dwindling revenue streams. Now, it's important to note that there's actually been, depending on what market you're in, a fairly significant uptick in certain areas of the construction industry. For example, home remodeling and renovation has seen a significant uptick in business. That has also contributed to a reduction in availability of resources and materials. Relative to the construction claims and to attorneys and those involved in litigation, we've also seen a fairly significant uptick in disputes, whether that be for delay claims, so damages allegedly resulting from delays in projects, or pay disputes. Now, this impact is not something that we've observed to be present at just one level. So it's not just at the lower tier subcontractors, but we're seeing it at every level of the chain. And a kind of a consequential result of COVID has been that the litigation process has slowed down significantly. We are now seeing cases that typically could have been resolved within a year, being pushed out to much longer than that because of a variety of reasons that I'll discuss in later slides. All right, the first thing, construction materials. What we see is cost fluctuating significantly, whether it's lumber, plumbing supplies, or other, whether it's fasteners, something like that. There's been a pretty easily observable fluctuation in costs in the last year. And that's caused a lot of contractors to change the way they contract. Often, a lot of the residential contractors are doing cost plus only at this time. You're also seeing a lot of supply chain delays and shortages, and then business closings as well. And that affects contractors, for example, when a subcontractor goes out of business, but also where you have a developer or owner who closes a business and therefore the project then terminates. One of the more common scenarios right now that we're seeing in the Knoxville market is a lot of hotel projects have been terminated due to the developer either going out of business or financing just falling through. Labor inefficiencies is also something that we see popping up quite regularly now. And we're seeing that both in our construction practice group and in our employment practice group with the firm. You've got employees that are either ill or they've come in contact with somebody with COVID, and therefore they're out of the office, either not working or they're required to telework. And as many of us know, and Steve, I think, will attest to this, there are technology challenges that are present for some of us who maybe have not adapted to the environment as fast as others. Of course, there's a learning curve. And in addition to that, there has been a significant increase, or there is a significant increase in committing to the infrastructure, technology infrastructure to support teleworking, whether that be through Zoom conferences, MS Teams, or what have you. You've also got your internal and externally imposed hygiene requirements to meet local and state requirements. And then you obviously, you've got to take your staff away from the tasks and jobs that they have been hired within their scope to perform. And now they're spending time to, for example, perform temperature checks, or they are, required to spend extra time sanitizing work areas, something like that. But that all takes away from the bottom line and results in increased costs and lost profit. Access limitations, we're seeing that quite a bit, especially on government projects. So if you're doing a lot of public projects, you've likely run into scenarios where either the government has limited access to the site or closed down the project in general. We've already discussed the hygiene demands, but at the end of the day, it's additional resources that are dedicated to address COVID concerns that would otherwise be dedicated to other matters that are required to run your business. And how is this impacting, or how is this manifesting within the context of construction claims? Again, we're seeing lots of delay claims, lots of pay disputes between developers, contractors, owners at all levels of the chain, and then much longer dispute resolution processes. And that's both from an ADR perspective, whether it's arbitration, mediation, and in the litigation process. And then finally, something that it's kind of our responsibility as attorneys is to evolve and develop contract language for our clients that provides adequate protection to them to address the pandemic right now. And there's a million different ways that is going to affect a business. So we're constantly changing contracts to address those different concerns for our clients. Delay claims, of course, the phrase that is common to just about any contract is time is of the essence. What that means a lot of different meanings, and it depends on what court you're before and what parties are contracting. But what it means within the context of construction claims is, unless there's some sort of justifiable excuse, which is likely going to be defined in the contract, the consequence from failure to meet some sort of deadline could result in termination or default, and therefore result in you not getting paid. There's also the concern of assessment of liquidated damages, and we're not going to get into a thorough discussion on liquidated damages, but there's a lot to that. Just know that liquidated damages cannot be assessed as a penalty, but they are essentially an attempt by a party to specify an adequate measure of damages in a contract before work is performed. Pay disputes, we see oftentimes now that starting at the top and then it just rolling downhill and getting to be a larger and larger issue as it gets further down. Tennessee has a different view than many states on the pay when paid versus pay if paid. And again, this is a general discussion, so we won't get into that. But what we're seeing is a lot of payments being withheld due to failures at the top to adequately plan for pandemic effects on the construction jobs. Litigation delays. Recently, we've had the Tennessee Supreme Court issue an order, and we anticipate that we'll likely have another order issued within the next couple of weeks. But currently, all jury trials across the state have been suspended through February 26, 2021. And if I were a betting person, I would say that will be extended at least another 30 days beyond that, if not more. In addition to that, all in-person proceedings in state and local courts in Tennessee have also been suspended. The limitation or the suspension on that is through January 29th. But again, we're going to see that pushed out further unless there's a dramatic turn in what's being reported as far as COVID diagnoses and treatment and vaccinations. That will also affect how long this gets suspended, how long the delays continue. All right, contract language. So again, I can't discuss everything that is kind of that I'm seeing as far as the evolution of contract language, but we're going to address a few things. At the end of the day, the purpose of contracts oftentimes is to allocate responsibility, and with regard to delays, you want to allocate it across. If you've got a subcontractor who has to perform a certain part of work before another subcontractor can go, you want to ensure that that subcontractor is going to be on the hook for whatever delays that he or she may cause that results in further delays down the line. Contracts, you want to use it both as a shield and a sword. So as a shield, you want it to protect you from claims up the line and then spread that liability down the line. But as a sword, you want to ensure that you're securing payment from up the line. And then also, to the extent that you might have to bring a third-party claim for, say, indemnity, you want to ensure that your contract protects your rights to do that. You also need to account for external influences, which is something I'll discuss in this presentation just a little bit more. And an example of that would be acts of God, whether that's tornado, hurricanes, global pandemic. Force majeure is a term that is used to discuss essentially external events that have an effect on a contract. And oftentimes it's things that are not foreseeable. So if it's not foreseeable and it's outside the reasonable control of a party, then force majeure provision might protect you from exposure or additional liability. And there's different variations of these clauses. Some clauses will contain just a non-exclusive list of examples, and then at the end of it, we'll include a catch-all provision, for example, or it'll have a list of things like global pandemics, acts of God, or anything outside of either party's control. And then the second type would be something that specifically spells out the type of event or occurrence that it's going to classify as a force majeure. and then offer relief to the parties as far as performance goes. Now, the question is, does COVID qualify as a force majeure? And the answer is, it depends. Again, it depends. It's going to depend on your contract language, what jurisdiction you're in, and more specifically, what does your force majeure clause, if you have one, say? What variation is it? Is it going to expressly address pandemics, or is there some sort of indirect reference to pandemics? If there's just an indirect reference, the court, when it's interpreting the contract, is going to look at the foreseeability of the event and then the intent of the parties. You also need to look to see if there's additional requirements contained in the contract to determine whether a force majeure provision is going to apply. And something that we see often is a notice requirement. So a contract will say that a party will be relieved of their obligation to perform for the following scenarios. However, the party must provide written notice within 48 hours from the date of discovery of such event that would prevent them from performing the contract. So if you've got a requirement such as that, you need to meet that requirement in order to have that relief. You need to review your contracts. If you have form contracts now, they really need to be updated to include a force majeure provision. If you use AIA contracts, they don't specifically address them. There's some indirect language in those, but again, talk with your attorney and help them, work with them to develop some sort of clause or language that's going to offer you some protection from a situation like we're currently experiencing. The other considerations you need to look at is the possibility of performance, and it needs to be something. So an event needs to be something that makes performance impossible, not just difficult. You don't get by just proving that you incurred additional cost to perform, or that it made it harder for you to perform. You have to prove that your performance of your scope of work was made impossible by the event. If you're working public projects, you know to look at the FAR, and that's what's going to tell you whether you're entitled to forgiveness or relief from your performance obligations. And I've cited two separate provisions here. Both of these address force majeures, and they address epidemics and quarantine restrictions as grounds for excusable delay. Now, what relief is typically granted? Well, you've got one. The most obvious form would be the excusal from further performance. But in some situations, it would just allow you to narrow the scope of performance. You also, in public projects, may be entitled to an equitable adjustment. In that case, you wouldn't necessarily have to prove that it's impossible to perform, but there's going to be some sort of burden you'll have to establish that your additional costs incurred were a direct result of that event, and therefore you're entitled to equitable adjustment. And then you need to file a request for equitable adjustment. And if you're familiar with the process, it's not a smooth process, and it's a process that can take some time. Other considerations, there is some relief made available through local, state, and federal programs. So if you are currently experiencing a significant impact on your business as a result of the pandemic, you talk to the local SBA, you talk to your attorneys, because there are relief programs out there for you. And then something that is near and dear to the attorneys is the effect that it will have on a business's insurance coverage, because off 95 to 99% of construction claims involve whether it's a surety or an insurance carrier. And the best way to protect yourself is obviously to have adequate insurance coverage. From a builder's risk perspective, often those policies will include a contamination exclusion. Now, most courts that have addressed that would not include a pandemic or COVID-19 to fall within that exclusion. However, you need to look at your policy and see what your policy-specific language says. Most of the policies will include civil authority coverage, so some sort of mandate or requirement issued by a governmental authority that requires you to shut down a project or something like that. that's likely going to be covered by builder's risk. You'll likely have, communicable disease coverage, but again, it's going to be policy specific. So take a look at your insurance policies. And then it looks like we're running a little over time here, so we will skip ahead here. How do you protect your company? 3 things you can do. 1, review your policies, talk with your insurance agents, and identify potential gaps in your coverage, because it's better to discover those gaps in coverage now as opposed to when a claim's filed against you and you get that reservations of rights letter, or you get that letter denying coverage. 2, speak to your attorney, update your contracts, your notices, and any other forms that you may have, but to include language that would address concerns and offer you protection from delay claims, or preserve claims for you against subcontractors for delays that they might cause you. So look at your contracts as a way to both preserve your rights, protect you, and to also, and this is something that's not thought of often, is to dissuade parties from filing frivolous or meritless claims against your company. Then 3, know what you're getting into before you sign your contract. We often hear, parties say, or clients say, well, I saw that provision in the contract and it gave me some concern, but I didn't think it would ever come up. Well, hindsight's 20/20, and hindsight can be very expensive. So if you have a concern in your contract, the devil's in the details. So talk to your attorney about it, whether it's in-house counsel or you have external outside counsel. And then the conclusion, I'll let Steve wrap this up here, but the 3 takeaways you can take from this presentation is most construction cases are going to settle because of the enormous cost of litigation. Now, arbitration used to be a more cost-effective means for resolution, but even arbitration now has reached the point where it is expensive, extremely expensive. It's still quite a bit faster than litigation, but both are expensive. Regardless, you need to be prepared, have a competent attorney on hand, be familiar with the work that's being performed, because the more prepared you are, the more leverage you have to settle something on the front end quicker and cheaper. And then have that understanding of basic concepts of construction claims. You don't need to have a law license to understand the basic concepts and know what you're getting into. What you really need to know is enough about the basic concepts to know whether you need to contact your attorney or whether you need to contact your insurance company. This is going to allow you to make an informed decision and give you some insight as to what the best way to resolve this particular dispute would be. All right, that's all I have.
Yeah, we are a little bit long now.
I think we have some questions, Steve. I want to pull up the chat there. I think there's a few questions.
Yeah, I was going to address, I don't know why I'm acting like that. The first question is, am I echoing horribly?
No, I don't hear an echo.
Okay, good. All right. The first is in a contract, if a contract includes liquidated damages, what classification of damages can that be expected to cover? Is it reasonable for a party to the contract to expect that to be the limitation of damages in the event of scheduling delays? The first thing I would say to that is it depends on what the contract language is. That would control, but as a general rule, in my experience, liquidated damages are going to be for delays. And so any damages that are the direct result of the delay are going to be limited by the liquidated damages for delay. But other damages would still be recoverable. For example, going back to our wall, if not only was there a delay and there was a liquidated damages provision that gave you X dollars per day, you would get that. But if they had also knocked over the wall, you would be able to recover for that as well. So again, ultimately, it's going to go back to the contract language, but that's kind of would be my basic response to that.
Yeah, and again, it's really going to depend on the language of the contract. You know, a court is going to analyze, you know, liquidated damages provisions to look at the intent of the parties. So if it looks like it's a penalty, the court won't enforce it, and they'll look to the more common measure of damages and compensatory damages. Steve, I don't know if you've had this happen, but a lot of times I'll have a client tell me, well, no, I have in my contract right there, it says this liquidated damages is not a penalty. And they think that's a bar, or that's going to guarantee that the liquidated damages provision is applied. But, you know, that's not necessarily the case, is it?
No, I mean, just because the contract says it's not a penalty, the court could still decide that it was excessive and punitive. So I've seen that happen.
Yeah. Looks like the next question we have here says, at the beginning of the pandemic, we were warned to watch for and be on guard against the redefinition of standard of care due to a number of potential factors of the virus. Are we seeing this in Tennessee? Yes, we're seeing it in Tennessee. It's not something I've seen a lot of, but you know, at the end of the day, the standard of care, when a court is assessing that, they're looking at foreseeability and the reasonableness of the parties. And since we are in the midst of, how long have we been, 9-10 months into this now, parties now have quite a bit of knowledge of what the pandemic is and what effects it's having on a business. So it's making the foreseeability of such effects more likely. And the courts are going to likely impose that requirement on contractors or engineers or architects in claims.
I would agree. Just briefly, I would agree with that. There probably hadn't been enough time for most of these situations where that would arise to work itself through the litigation pipeline. But I think ultimately, like Matt said, it's going to come down to what's reasonable. If the COVID situation has required parties to change how they operate, then the question is going to be when they made those changes, were they reasonable? And then ultimately, it's going to be decided by other folks in that field. So the answer, I believe, is definitely yes. But the ultimate answer is going to be yes. It may have changed, but the ultimate question is going to be did how you react to the change, was that reasonable? So I think that's the answer. And I don't see any other questions. So
actually, it looks like there's one more. It looks like, Steve. Yeah.
Okay.
So in your experience, and anybody who wants to drop off, feel free to do so. But we'll address these questions. In your experience relative to residential remodeling by a licensed contractor, jobs size range from $25,000 to $300,000. How many pages in length do you see contracts averaging? For example, their contract is 4 to 5 pages. But from the residential remodel perspective, I've seen quite a variance, but I've seen good contracts written in 2 pages for some projects. And I've seen typically, if you've got a 10-page contract for a residential project, you've got a lot of stuff in there that either is unenforceable or it's not applicable. Every project you have, you should be looking at your contract to ensure that it is tailored to the project itself. And it doesn't require a whole rewrite of the entire contract, but at the very least, you actually need to look at your contract and make sure that it is addressing the work that you're hired to perform. 4 to 5 pages, I think, is pretty common. That doesn't seem excessive to me. Again, it's going to depend on the job itself and what you have in that contract. Steve?
Yeah, I would agree with that. I think 4 to 5 is probably about average, and I'd say that's about right. If you get up to 10, then you kind of start wondering, on a project of that size, you kind of start wondering what else is in there. So I think that's about right.
Okay, it looks like we got a question. Tanya, you can probably address this directly, or if you want to with the group. But someone wants to know whether they need to provide their AIA numbers. Okay, you got that already.
We'll submit the names, and AIA will submit it for credit. So we're good there.
Okay, great.
Okay, great.
I think that's all we have.
All right, thank you very much.
All right, thanks everyone.